This week we'll be focusing on something that isn't grammar and isn't plain English drafting. We're moving away from all of that. We're focusing on actual specific drafting tasks now, and this week's topic is correspondence. So what you should note from the study guide is that the very first thing that we do is return to our first consideration from week 1, which is consider the purpose, consider the context, and consider the audience. Why is that important when drafting a letter? Well, the purpose, context, and audience will shape the letter in terms of its content and its tone. So let me give you an example. Sometimes letters are merely informative. They're designed to tell someone that they must attend court on a particular date or to note receipt of documentation. In those instances, that context and purpose will mean that the letter is short and to the point. It certainly won't attempt to persuade anyone of anything. Letters can also be a request that the reader undertake a particular action or a request that they refrain from doing something. An example might be requesting that a client complete and return a form. Again, that will shape the content of the letter. It will be short and to the point. Note that, in contrast, a letter that attempts to be persuasive, for example, an offer to settle, may include persuasive language. It will be much longer. It will include persuasive language designed to strongly assert the client's position and convince the other party that it's sensible for them to accept the terms proposed. And of course, if a letter is designed to provide advice to a client, then again, that will shape the content and tone of the letter. But also, in that instance, the audience is really important too. You must bear in mind that a client has no legal knowledge or very little legal knowledge and therefore won't understand reference to legal terms or legal jargon. That client will need the law explaining to them. You can't assume that they know anything about that particular area of law or the relevant court procedures. If you contrast that with where the recipient is a member of the legal profession, you can assume that they know the relevant court procedures that you're talking about. Now, aside from being aware of the purpose, context, and reader when you are drafting, because that will shape the content and tone of your letter, it's also important to ensure that your letter complies with the usual format for a letter. So as you can see on the slide, there's a basic structure for a letter, and it really doesn't matter whether you're writing to your client, your opponent, or a third party. It still takes this standard structure. Now, the reading for this week and the study guides go through each of those particular sections of the letter in more detail, but I just wanted to emphasize that the introductory paragraph and the penultimate paragraph are very important. It's really important to identify to the reader at the outset why you are writing to them. So this should be a short statement indicating what you require from them or what you want them to do or the purpose of writing. And that should be mirrored in the penultimate paragraph. That's important because, of course, you need to remind them at the end, after they've digested the body of the letter, you need to remind them at the end what you require them to do or what your purpose for writing was. Note that in addition to identifying the reason for writing, if you are writing a letter in response to correspondence you have received from someone, that should also be noted in the introductory paragraph. And the reason for that is because it articulates to the reader that this is a reply and response, and it also helps in terms of identifying the chronology of the exchange of correspondence between the parties. So when providing advice to clients in a letter, you need to remain objective in the way that you deliver the advice. You identify if there's a range of potential things that might happen because, say, the law is ambiguous or it's not clear whether the evidence supports their case. You'd need to identify the range of potential things that may happen and then say which is the most likely and why. Once you've given them your reasoning on that, you also need to provide them with practical advice. So what does that mean for them? Should they continue with their litigation? Should they make an offer to settle? Should there be more investigation and more gathering of evidence? Or should they attempt to mediate with the other party? So that practical advice is just as important as the legal advice. So when drafting that letter to your client, you need to explain the law simply and concisely. Where possible, avoid going into great detail about the law, and certainly don't quote large sections of text from a case or a statute. Instead, provide them with a summary of the law that is explained in terms that they can understand. You really need to help them navigate through the law rather than trying to teach them what the law is. Really, you're there to deliver a brief summary of the law and get to the point of the letter, which is to deliver advice as to what they should do next. Now, moving on to huge, big warning signs here. Whenever you reveal information about your client in a letter to another, whether that's an expert instructed in the proceedings or your opponent or a third party, you must ensure that you do not reveal confidential information unless you have clear instructions from your client that you are permitted to do so. Remember also that you can weaken your own case by providing the other side with information that they currently don't have access to. So it comes back to focusing on what is the purpose of this correspondence. What am I trying to achieve with this letter, and what is the minimum amount of information that I can reveal to achieve that particular purpose? Now, the study guide has a section dealing with confidentiality and also without prejudice correspondence. It's really important that you go through that so that you have a basic understanding of how that operates in practice, and that we don't just rubber stamp everything with without prejudice, because that means that we then can't rely on that letter in subsequent litigation when we might actually want to use it as evidence. Time for another huge red warning sign. There are a range of ethical considerations that must be at the forefront of your mind when you're writing to your opponent. For example, Rule 22 of the Australian Solicitors' Conduct Rules states that a solicitor must not knowingly make a false statement to an opponent. Note that even if the false statement is made unknowingly, the solicitor must take all steps necessary to correct that false statement once they become aware of it. So that's a really onerous ethical obligation there, and it applies to all conduct, including correspondence. Note that Rule 34 adds further obligations on lawyers when corresponding with others, and that is set out and discussed in the study guide, so make sure you have a look at that. In fact, it's a really good idea to get hold of the Solicitors' Conduct Rules so that you can review them for yourself and make yourself more familiar with the range of ethical requirements. I'm really looking forward to seeing what you come up with for this week's workshop task. It requires you to draft a letter proposing settlement terms to the other side. And note that this is a really important task for you because it's going to help you prepare for your letter of advice to a client. So please make sure that you have a go, you attempt the actual exercise and bring it with you for a bit of feedback. So I'll see you in the workshop.